SJC-13366, Chad Marsh v. Massachusetts Coastal Railroad, LLC, and another.
Hey, Attorney Nathanson.
Good morning, Chief Justice and Justices of the Supreme Judicial Court. I also have with me, I would literally say, guilty of a pun, my right-handed man, a new associate of ours. Connor Lang is his name. Thank you, Your Honor.
Could you talk a little louder, please? Thanks. Thank you.
Thank you. As Your Honors may notice from this case, the primary issue in the case is federal preemption. And having been doing railroad work for a long period of time, this is the most pervasive and the most exclusive statute in the U.S. Code on preemption. And it has been the subject matter of many cases. Just as a little bit of a background, the railroad industry is the most, or one of the most, regulated industries in the United States. And it has been that way since the Civil War, right up to the present date. And if you remember a couple months ago when we had that national rail emergency, that's all part of it. And various acts were passed. The principal act that we're here before today is the ICCTA, that's the Interstate Commerce Commission Termination Act of 1995, which was passed by Congress to supplant the old ICC. And what it did was, it was definitely intended to be almost, if not complete, regulation of the rail industry. The purpose of the ICCTA was very simple, and you can set forth in my brief the legislative history, is to have uniformity throughout the country, the 49 states plus Mexico and Canada. And the purpose was obviously, as indicated in the legislative history, not to have what they call a balkanization, or states, having patchwork rules and regulations for railroads. Well,
is it patchwork regulations for railroads, or wages of railroad employees, or regulation of railroads? Which is it? Because the language here, although you say is really quite broad, is not as broad as the case upon which you rely. So can you explain to me how broad this is?
Very broad. The case
Well,
law,
I know very broad, but what specifically, how does it touch upon the wages that employees of somebody providing your client's services to railroads? How does it govern that?
Okay. Let's look at the statute, because the first thing you always do is obviously look at the statute. 49 U.S.C. 10501(1)B. It's actually B 1 and 2. Says, quote, the jurisdiction of the board, they're talking about the Surface Transportation Board, which was established by Congress, over transportation by rail carrier, I'm going to skip around some of the words, and the remedies provided in this part with respect to rates, classifications, rules, practices, routes, services, facilities of such carriers, and the second section, construction, acquisition, operation, abandonment, or discontinuance of spur, etc., sidetracks, etc., is exclusive. Next port.
So where do wages fall into that?
Well, if I can get, just take 1 second.
That would be great if you could get to it.
I'll get to it.
Where do wages fall into that?
Okay. What happens is, if you look down under Section 3A of that act, it says, notwithstanding paragraph 2 is that mass transportation exception. It says, a local government authority described in paragraph 2 is subject to the applicable laws of the United States related to, and I'm going to skip around, number 2, the representation of employees for collective bargaining, employment, 3, I'm under 3, employment, retirement, annuity, and unemployment assistance or other provisions related to dealings between employees and employers.
Okay, so that section 3 does not apply, it doesn't say that employment is not subject to state laws. It just says that it is subject to federal law.
Well, subject to federal law to me means that it's a federal law means it's federal law. It's subject to, it wouldn't be subject to state law. It's subject to.
Well, there are certainly things that are subject to both.
Well, not for the railroads, not for that.
Can
If
you give us examples of instances where the state's been able to exercise its police power where it hasn't been preempted?
Sure. I'm glad you asked that question, Judge, because the few and only area where preemption doesn't apply on land use situations, zoning. Everything else is completely regulated by the Surface Transportation
So
Board.
when we, or the law clerk does the research in this case on preemption, and we say, give me all the preemption cases, it's only gonna be, non-preemption cases, I guess, it's only gonna be zoning?
Those are called incidental. They're incidental things that have really are not necessarily for what we call the management and operation. You see, the whole purpose
Yeah,
of
I just wondered
preemption.
about I had read the brief, but I was just wondering about broad categories, but you're saying it's basically zoning.
Yeah, it's just land use, Judge.
I thought it's laws of general uniformity, though, right? I mean, if you spilled a toxic substance, wouldn't that be covered? You know,
Covered for preemption?
would not be preempted. I mean, if there's laws related to, I don't know, contamination or something like that, that wouldn't be covered?
Well, that's probably, I believe there are regulations from the Surface Transportation Board about toxic materials, as we've seen in the newspapers very recently, that regulate that. But I'm not sufficiently sophisticated to answer that question, but I do know economic
Distinguish
reg.
between those incidental?
Sorry, Your Honor, I didn't hear you.
How do we distinguish between those incidental laws of general applicability, such as the zoning cases that you reference, versus things that are exempted?
The case law answers that very clearly and concisely. If it affects the management and/or operation of the railroad, it's preempted.
And you're saying zoning doesn't affect operations?
No, that's correct.
And why is that?
Because the other purpose of the ICCTA was economic regulation, to make sure that rates were uniform, to make sure that, you know, the railroads can make a living, you know, that they didn't have to, you know, jump through hoops and rinks to make a living. And that's why economic regulation is under the jurisdiction, because if they have jurisdiction clearly over the setting of rates, how do you set rates? You set rates based upon your operating expenses, et cetera, et cetera. And in this particular case, just think about it. They're claiming, assuming they're right, they're claiming that the defendant paid $15 to $20 an hour. They're saying that the prevailing wage is $65 an hour. And if you don't think that if that were the law, that wouldn't affect the management and operation of a railroad, I don't know what else would.
But zoning would not affect the management and operation?
That's correct. That's correct. Zoning is, it's called incidental. If you look at the case law, they talk it incidental. It does not affect the operation. You see, the purpose, again, of
Can you, before you go sort of more generally again, because I understand your argument that, you know, applying the prevailing wage would be extremely disruptive. What I'm trying to understand is the exception. So the ICCTA provides, quote, except as provided in paragraph 3, the STB does not have under this part over mass transportation provided by a local government authority. So, and I have trouble understanding his pleading, but he's suggesting that some of the projects he worked on are, you know, this South Coast rail line. So that's a transportation provided by a local government authority. Why doesn't the exception apply?
Because MassDOT doesn't provide public transportation. See, the
I thought-
exception,
But I thought there's also, it also includes a person or entity that contracts with the local government authority to provide transportation services.
the contract here was with MassDOT that does not supply public transportation.
So because
And-
the Department of Public Transportation doesn't itself provide transportation,
That's
that-
correct,
that
Judge.
seems to be a fine distinction.
It is the correct distinction, because
So
think about,
if it were an MBTA project or a commuter rail project, he might be entitled to prevailing wage?
maybe, maybe not, depending. But you see, let me answer that question in another way to give you the overall picture.
Right.
Railroads are part of a national network of rails that are used by freight and passengers. And if you're right, or he's right, my brother is right, that the MassDOT comes within this subsection, which they don't.
Right.
That would mean every railroad in the country, because these railroads share both freight and passenger. They both use the same lines. So what that would mean that every railroad would be literally exempt because there's a possibility of a use. And by the way,
Well, I don't think he would be arguing that everything would be exempt. It would be that if you're working on a project that's paid for by the local transportation agency, then you'd be exempt. I think that's his argument.
well, the argument is wrong, because first of all, the payment came from MassDOT, which is not a local transportation authority. They don't run mass transportation, so they're clearly accepted. And, you know, there are complications even here for the Commonwealth, because getting to the second issue in the case,
And by the way, are there cases that tell us that the Department of Transportation does not meet the definition of a person or entity that provide, whatever that language is about a local, does not have, it's not a local government authority? Are there cases that say that?
well, it's not cases, it's just statutes, and MassDOT does not provide public transportation, period. There
Is
are
that
no-
something that
What
we
do they
can
do then?
determine at the pleading stage? Excuse me.
I'm sorry, no, go ahead.
I'm sorry, Judge?
Is that something that we just take judicial notice of? I mean,
Oh,
you're on a motion
absolutely.
to dismiss here.
Well, I'll go one step better, Judge. There are no rules or regulations that MassDOT has over railroads. There are no statutes, there's no authority here in Massachusetts that regulates railroads under MassDOT or any other agency. It's, when they talk mass transportation, and my brother cited the case, it's the MBTA and our local regional authorities, that's called mass transportation. They're the exception. They're accepted from the ICCTA, but not MassDOT or anybody else. And I wouldn't get caught up in that, Judge, because that's really not the issue here.
Well, yeah, I know, but the issue is that you're here on a denial of a motion to dismiss. And as you acknowledge, normally a denial of a motion to dismiss is not something that's appealable. And the reasons that it's not is because we like to conserve judicial resources and have
Right.
one appeal at one time. And I'm wondering, on the face of the complaint, which is our test for motion to dismiss, if we can divine all that you're telling us about MassDOT, about MCR, about the South, I think it's the South Coast Rail that Mr. Marsh was working on. Are all of those things that you can tell from the four corners of the complaint, or do we have to send it back for you to file a motion for summary judgment, at which point you would submit affidavits?
I don't think so, Judge, because it comes under the present execution doctrine, which is like charitable immunity, things like that.
Yeah,
In
do you have any
federal-
cases that allow the doctrine of present execution to apply to the preemption context?
I don't know if I cited any or not, but it's very similar. It's identical to charitable immunity. It's because if Your Honors decide that it is federally preempt, that's the end of the case. There's no basis. Why should we have to go through a full trial if the first issue of federal preemption,
Well, you might not have to go through a full trial. You might have to submit affidavits for the things that you're telling me in the reply brief.
well, I don't even think my brother challenged it, by the way, just as,
Well, he writes, his complaint is, unclear, but he says MCR entered into the South Coast Rail contract with the state of Massachusetts. So, and now the state of Massachusetts is kind of an umbrella, right? We got the MBTA, we got commuter rail organization. I mean, how do we, based on that, do what you say, which is, because I take it the state of Massachusetts generally has local transportation, right? It uses the MBTA.
well, does it come under the MassDOT? No. MassDOT does
He
not
doesn't say
regulate the
MassDOT. He
MBTA.
says the MCR entered into a South Coast Rail contract with the state of Massachusetts to restore commuter rail services. I don't know what that means, but we can conclude, you say, because the state of Massachusetts doesn't apply local transportation?
That's correct. They do not supply public transportation. That's common knowledge.
Well, common knowledge is, we're stuck with the law, so
Well, I understand, but there are no, the MassDOT does not have any buses, trains, or anything like that. What they do.
Why isn't preemption and its importance recognized through applying the doctrine of present execution after summary judgment?
Because I think it's very similar to charitable immunity. It's something that the first question is, is there a bar totally to the complaint, like charitable immunity? And federal preemption is and should be, because
If it's
if you don't
applicable.
get over federal preemption, that's the end of the case.
If it's applicable.
Yeah, the question is
Well,
whether there are existing facts that need to be shown to warrant summary judgment phase. Then I could see present execution, but
Ironically, my brother never challenged that either, because I think we both recognize that the issue of federal preemption is the first issue. I haven't even talked about the second issue, but if we, and I see my time is up.
Your time is up.
Could I ask one last
Yeah,
question?
sure, of course.
So, again, I'm going to ask your brother these questions, but I don't understand what he does. So, Chad Marsh is an equipment operator. His job responsibility, I'm reading from the facts of the complaint, included operating boom trucks, backhoes, loaders, and tampers. So does he dig to put in rail? Is that what he does?
Yeah.
Is that your understanding?
This is all rail, yeah,
So he just, he operates a backhoe and lays down rail.
correct.
So isn't that your best argument, that he's putting in rail? And rail goes for everything, right? I mean, any time a train runs on it,
Correct.
it's not, and that's what he does. He's not building the facility for the South Coast Rail. He's just putting in rail tracks.
Correct.
Okay.
And by the way, getting to the public project issue, the reason why it's not a public project, there's a statute in Massachusetts preventing people from going on rail tracks. Actually,
Counsel, I'm looking at what does MassDOT do? They have references to their work on freight and passenger rail programs.
correct.
But you're saying they're not at all involved in rail?
They're not involved in any public transportation. What MassDOT has is they own certain rail tracks. And what they do is they lease these rail tracks either through special easements or license agreements to various railroads. That's their only involvement in obviously they maintain the tracks, which is why my client, through an operating agreement, worked for them. But they do not provide transportation, period. They just happen to own these set of tracks.
Are there any other questions on any of it?
Any-
Okay.
Thank you, Your
very
Honor.
much.
A pleasure.
Okay. Attorney Moselle.
Sorry for going over.
You're not the first.
Good morning, Your Honors. Raven Moslinger for the appellee. May it please the court. The appellants are demanding an extraordinary form of relief here. Their position is essentially that every single state wage and hour law in the country that applies to railroad workers is preempted, and that's not the case. First, there's no...
Well, all we're really having to decide is whether the prevailing wage law is a very distinct sort of, protection that creates a whole different wage structure, and it's Massachusetts specific. So that's a big deal, having that apply to railroads, isn't it?
Yes, but I think it's like any other minimum wage statute.
It's far from a minimum wage statute. It's a giant boost, and it changes the whole wage structure, right? So
does the minimum wage law, so does the overtime law. What you're describing is higher rates of pay somehow affects the operations or
well, it's
management.
a Massachusetts-specific wage scale for public construction projects, particularly sort of, big public buildings and other things. So it's different. And do we really apply that to the railroads, which are sort of an intensely federal integrated system?
Right. Well, so, Your Honor, what we look at is the preemption language within the ICCTA, which is exceedingly narrow. This court has a lot of experience,
Looks exactly opposite.
Isn't it actually quite broad?
Well, not in comparison
And
to...
so tell me how it excludes your client and the prevailing wage law?
Because it only preempts laws that regulate the railroad industry.
And how does it not regulate the railroad industry if you have an across-the-board rate of pay, wages, that is, I don't know, let's say 5 times as much as the minimum wage?
Well, because that's a law of general applicability that applies to all market participants on equal footing.
In Massachusetts, but if I have a railroad that goes across the country, then are you saying that for each different employee, I have a separate set of prevailing wages that if I'm a railroad, I have to comply with?
Of course, and that's true with
And you
respect
don't think
to...
that will disrupt interstate commerce?
No, because there's already a patchwork of different labor agreements across different states. So there's already different unions in different states reaching agreements with management and reaching agreements as to different rates of pay. So there's already a patchwork.
And don't those different union agreements come under the board's, the STB's jurisdiction?
No.
No.
They do not.
Okay, so explain that to me.
They fall under the Railway Labor Act. So the STB, the preemption here is exceedingly narrow. This court has experience applying F-Quad A preemption, which is exceedingly broad and relates to rates and prices of motor carriers.
The federal courts say the exact opposite. They describe it as a very broad preemption. So saying it exceedingly narrow.
It is, but there's a distinction that's been drawn by the courts. On the one hand, laws that restrict railroad operations, like scheduling and train size and train speed, and the time, for example, that a train can occupy particular railroad tracks, those are the sorts of laws that are preempted. On the
Well, I mean, you say that, but then the Seventh Circuit clearly held the other way.
Well, the Seventh Circuit, on a field preemption analysis, not on an express preemption analysis, which is what I'm referring to now, what they contend is that under the ICCTA's express preemption provision, that state wage and hour laws are preempted. My point being that that's never been held by any court, and courts have created a distinction between laws of general applicability, like state wage and hour laws, that are not preempted, and then state laws that actually regulate railroads by restricting their operations in some way.
You've given us examples, one state, of course, can't say train speed or size of rails. How about the flip side of that question, which is what I asked counsel, in that what has been found to be incidental? He mentioned zoning. Is there anything else other than zoning?
Zoning, licensing laws, building codes, common law tort claims, environmental statutes, things of that nature, right? Things that are incidental. And I think this was the 10th Circuit that sort of described it this way, is are you suing them and they just so happen to be a railroad.
That would be a tort claim, for
Correct.
example, correct?
Exactly. So these, where states are exercising
But this
their-
is, but again, this is construction of track, right? What could be more sort of essential to railroad operations? And also, the prevailing wage is not a general law of applicability. It applies specifically to public construction projects. It's not like zoning or, laws of general uniformity that apply to everything out there.
But it's not targeting railroads specifically. That's the distinction, is
So
that,
if Mr. Marsh swung his heavy equipment boom negligently and hurt somebody, there could be a state law tort claim.
Of course.
Not preempted.
of course.
But here we're dealing with, what do we pay? Do we pay people $63 an hour or $24 an hour in Massachusetts?
There's no material difference between those two things. I mean, other than them being very different laws, but those are laws of general applicability that apply to all market participants, and they are not preempted. The authority we've cited.
If they pay $24 an hour in New Hampshire, then they go into Massachusetts and they get paid $63 an hour?
Well, yes, if they're, I suppose if New Hampshire doesn't have prevailing wage laws,
right.
then perhaps so.
How wouldn't that impact operation, that type of difference in rate of pay?
I don't know. It would cost more to operate, but that's not managing their operations, and that's really the distinction. Is the increased costs of participating in Massachusetts economy is not the sort of thing that's preempted under the ICCTA.
Well, I think that, I just don't buy that. I mean, the railroads are financially constrained. That's one of the issues that drives costs. I mean, I mean, this person, again, I'm trying to figure out what he does. What does your complaint say he does?
Well, that he operated equipment, including backhoes and
And does he just
campers.
dig rails? Is that what he does?
I think in part he levels the ground so
But
that
for
rail can be
putting
placed.
rail track in?
Sure.
So when he does that in Massachusetts, it costs 63, but if he does that in Rhode Island, they don't have prevailing wage, it costs 21. And he works for a company that does, as you allege in your complaint, integrated rail service, right?
Sure.
So I just don't understand how that doesn't get us in the mix with them.
Your Honor, this court is constrained by the language of the express preemption provision in the ICCTA, and every single court.
I'm trying to interpret it, and it
Right.
says construction, and this seems to be construction of rail.
Your Honor, it says the regulation of railroads.
But if you read the rest of that, there's express reference to construction in that direct conflict provision, isn't there? I mean,
Correct. And the
What does that mean
STB,
to you?
the STB has authority over construction of these projects. It does not say wages. It does not say the rate of pay. It says construction. So things like how high a rail depot can be is something that the STB would have exclusive jurisdiction over. With respect to rates of pay, Congress could have included that in the statute, and they didn't.
So Massachusetts can say, if you want to build a railroad in Massachusetts, I want you to I want you to pay $1 million a foot, because they don't really want that railroad. That's okay?
No,
Why not?
because that would be with respect to they would be regulating how a railroad constructed.
That's what they're doing here. They're saying, I want you to pay 63 rather than 21, and it's just an amount. Okay, I want you to pay 163 or $1,063,063.
Well, the hypothetical with respect that you provided was essentially only applying to railroads. It is targeting a railroad. The prevailing wage laws don't target any particular market participant. They are laws of general applicability, and that's the distinction the courts have. Many courts have already interpreted this, and they have drawn this distinction between, are you limiting their operations? Are you saying after midnight you can't run a train through our town? Or is it a general law of applicability that applies to all market
I'm sorry,
participants?
when you say many courts, are you saying many courts have interpreted this in a prevailing wage context?
Not in the prevailing wage context, but in drawing that distinction and saying, look, this is not like other preemption. This is not F quad A. This is not other forms of preemption that relate to rates and prices and the business structure of motor carriers or railroads. So under the ICCTA and all the authority that exists out there, there's no express preemption. Unless there's other
So
questions.
why isn't there field preemption then?
Well,
Why is the Sixth Circuit wrong and the Seventh Circuit?
Well, so field preemption exists when Congress is so regulated extensively within a particular area of law that it's left the states no room to legislate itself. And so the process, when you do a field preemption analysis, what you do is you define the field of state laws that are potentially being preempted, and then you compare it to the federal laws in the same subject matter. It's an apples-to-apples comparison. So we have state wage and hour laws that apply to railroad workers, and we compare them to whatever federal statutes are out there that regulate the wages of railroad workers. The only statute that potentially touches upon railroad workers and their wages is the Adamson Act, and that's primarily what the Sixth and Seventh Circuit pin their opinion to. And so I think the history and context of that statute is very important. So right before the Adamson Act was passed, railroad workers and management had a dispute over number of hours that railroad workers were working, whether they should have 8-hour days or 10-hour days, and what they should be paid for extra time. Negotiations broke down. The President of the United States got involved, couldn't broker a deal, and so the railroad workers threatened a general strike, which, if that had happened, would have crippled the United States economy. So in an emergency action, Congress passed the Adamson Act. The Adamson Act does two things. One, it established an 8-hour workday for railroad workers. And number two, for 10 months, it froze workers' wages, railroad workers' wages. Those are the only two things the Adamson Act did. It did not set rates, did not tell anyone how much to pay anybody. It just froze the wages because they couldn't agree. And thereafter, after the freeze, they were left to negotiate their wages and reach their own labor agreements. Now, the Sixth and Seventh Circuit, what they did was they took that legislative history and that context, and they took it a step too far.
They said basically it's a free market exercise. You, individual employee, negotiate with you, railroad.
Right.
And that, as a result, created a negative implication as to preemption.
Exactly.
So why is that wrong?
Well, that's wrong because there's nothing in the history or the context or the text of the Adamson Act that suggested that Congress intended to forever bar states from regulating with respect to the wage and hours.
When was the
of
Adamson
railroad
Act
workers.
passed? Do you remember?
1916.
1916. And were there minimum wage statutes at that time?
At that time, the Fair Labor Standards Act had not been passed. The Fair Labor Standards Act, I think, was passed in 1938. So overtime laws were not pervasive, if at all existent at that time. And so it's one thing for the Sixth and Seventh Circuit to say, well, they're going to be left to private negotiations over wages after this temporary freeze. It is an extraordinary and quite a different thing to say that Congress intended to bar states forever from regulating with respect to the wage and hours of railroad workers.
And
Now,
did the Seventh Circuit address the ICCTA?
It did not. It cited, I think, the statute, but it didn't address it with respect to the express preemption provision. Now, here's the test for field preemption. You must find that Congress has a clear and manifest intent to forever bar states from regulating with respect to the wages of railroad workers. And there simply isn't that clear signal from Congress. If Congress intended to bar states from regulating with respect to the wages and hours of railroad workers, it could have easily said so at any point. It could have included that in the Adamson Act or any other statute, but it hasn't done that. And beyond that—
I'd like you to address the exemption for local transportation. Because if you lose the first one, you still have the possibility of getting it within here. So tell me why your opposing counsel's wrong that MassDOT doesn't provide transportation, so this doesn't apply.
And MassDOT's not cited in our complaint. This
So,
is.
so just tell me how you meet this. The term local government authority includes a political subdivision of a state and authority blankety blank. Includes a person or contract. Just tell me how you meet this definition here.
Of course, Your Honor. So one of the projects that, there's actually additional language in the statute that relates to local projects that I think is helpful, and that's A2A. The STB doesn't have jurisdiction over transportation that isn't part of the interstate rail network. So one of the projects alleged here was a local commuter rail project that was intended to connect Boston to Southeast Massachusetts. So it's a local, the
Are you
intent
talking
of-
about the Southeast Rail Project?
Correct. And so the intent of that project is to provide local commuter rail service between Boston and Southeast
But
Massachusetts.
I'm confused again. Again, I understand the complaint's bare bones, but the complaint says he lays rail. Isn't that rail going to be used, not just, that rail is going to be used for any train that goes on those tracks, right? It's not just for, he's not been hired to work on the Southeast Rail Project. He's been hired to put rail down, right?
Well, Your Honor, we're at the pleading stage, and what we've alleged is that it was a local commuter rail project. There are no facts from which the court could draw the conclusion that the rails are going to be used for some interstate purpose.
Right, but you're
We can't infer that freight is going to be carried on the same rails?
With respect to that project, I don't believe so.
even though you say in your complaint that he's you talk about their integrated freight and rail again, it's artfully done, but I don't know if you've done enough. You've avoided problems, but I can't tell if you've given specifics enough.
I wasn't seeking to avoid problems. I was seeking to allege the facts as we understood them from our client.
They're kind of minimal, so.
I understand, but the pleading standards are exceedingly low, and we have to state a claim for relief. What we've alleged is that at least with respect to one project, that it was a local commuter rail project. That would be.
So tell me how this how this particular contract meets that definition.
Sure,
okay,
so.
Based on the complaint.
Right, so what we've alleged is that the defendant contracted with the Commonwealth of Massachusetts. This was one of the projects. I think it's reasonable to infer that commuter rail service that's being restored is going to be operated by the Commonwealth of Massachusetts.
So just again, to get into the specific language, it includes a person or entity that contracts with a local government authority to provide transportation service. You're saying that Massachusetts provides transportation services? Is that how you meet this? You're contracting with Massachusetts, and Massachusetts provides the transportation services?
Yes, Your Honor. So the Commonwealth, of course, is made up of a number of political subdivisions, including the MBTA and DOT, et cetera. So that is why we've alleged that they contracted with the Commonwealth to restore commuter rail service.
So even if a commuter rail company is the actual one that's providing the services, you feel that you've alleged enough to cover that?
Well, sure. So again, I think you cited to this portion of the statute an entity that contracts with the government agency as well is considered to be.
Right, but the government agency has to be providing the transportation services.
Sure. I think you can draw a reasonable inference from the complaint that if a company contracts with the Commonwealth of Massachusetts to restore commuter rail service in Massachusetts, that it's going to be operated by the Commonwealth of Massachusetts.
Does anybody have any other questions?
No.